It was a medical malpractice case. Throughout the entire 2-year litigation, the defense kept telling me we had no valid basis for a case, and their case was totally defensible. You want to find out how I knew that they were bluffing? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney practicing law here in the state of New York. So now, during the course of this litigation, every time I saw the defense attorney, he told me, listen, where are you going with this case? You have no valid case. And I kept telling him, listen, I do. I have a valid medical expert who tells me that I have a great case. It's you, on the other hand, who doesn't have a good case. And every time I saw him in court on the status conference, he would tell me the same thing. Every time I saw him at one of the depositions in this case, he'd tell me the same exact thing. And I told him, you're wrong. I'm telling you, we have a valid case. So how did I know that they were actually bluffing? You want to know how? Because in every one of these medical malpractice cases, we are required to provide expert witness information to our opponent. And we have to do that at certain times during the course of the litigation. Once we've retained a medical expert, now we are obligated to notify our opponent that we've actually hired someone to come in and testify at the time of trial. We have to give the defense the qualifications, the credentials of our particular medical expert, as well as what he's going to be talking about. And now, what do you think they have to do? They have to hire their own medical expert if they're going to be bringing one in, and they have to do the same thing. They have to notify us of the same information. They have to tell us the doctor's credentials. They have to tell us the substance of what the doctor will be talking about. Now, how did I know the defense was bluffing? Because as we were getting close to trial, I had given them my expert witness information long ago. And every day I'd be looking for their expert information. Where in the mail is it? They hadn't sent it to me. Every day passed by. They still hadn't sent it to me. Now we appear at a pretrial conference. I knew they didn't have an expert. I knew that no expert would support their defense. Why? Because they didn't have a valid defense. So when we went in for a pretrial conference, I knew at that point that they were now ready to settle this case because there was no way they could go to trial since they didn't have a medical expert to back them up. That's how I knew they were bluffing. So why do I share this great information with you? I share it with you just to give you an insight and an understanding into what goes on in a medical malpractice case here in the state of New York. You know, I realize you're watching this because you've got questions or concerns about your own particular matter. Well, if your matter did happen here in New York and you're thinking about bringing a lawsuit, seeking compensation for the harms and injuries you suffered, and you've got legal questions, what I encourage you to do is pick up the phone and call me. I can answer your legal questions. You know, this is something I do every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.